Auzenne. Mr. Smith, you have chosen 17 minutes to present your argument and reserve 3 for rebuttal, and if you'd like to begin, you may do so.
Yes, may it please the court. A grand jury indicted Dr. Auzenne on 8 counts based on his alleged participation in a fraudulent prescription scheme. Following trial, a jury then acquitted on 7 counts and hung on the 8th. The issue is whether the double jeopardy clause bars a retrial on the hung count. It most certainly does. In acquitting on counts 1 through 7, the jury necessarily decided that Dr. Auzenne was not a participant in the scheme alleged in the indictment. But in a retrial on count 8, the government would have to prove that Dr. Auzenne failed to disclose the existence of the same alleged scheme, a scheme predicated on his participation.
Well, I don't necessarily read the indictment that way. Isn't it, just talking about possibilities, isn't it possible that the jury may have found he was not a participant, but, per the government's argument, that he figured out that something awry was going on? I believe there was some testimony about that, and that he just knowingly did not disclose it in that affidavit, even though he wasn't a participant.
No, Your Honor, I don't think you can read the indictment that way. The indictment, as alleged, still focuses on Dr. Auzenne's participation in the scheme. We know this for 3 reasons. First, the indictment alleges and defines a fraudulent prescription scheme. This is on page 1037 of the record. That's paragraph 36. And it includes a 3-step chain in which my client's active participation is involved. So my client allegedly pre-signed scripts, directed his assistant to then fill in patient information and fax those scripts, and then understood that Mr. Moran was going to complete the rest of the information and submit those scripts. That alleged scheme is then incorporated by reference in count 8. That's at page 1036, I believe, or 1046, pardon me, in the indictment. And if you look at the allegations there, it's a restrictive relative pronoun. They have to prove that he omitted that. And then everything that follows is still predicated on that scheme. The government focuses just on the last part, but you can't focus on the last part in reading it and assume that my client wasn't aware of the scheme. We know this for a couple of reasons. First, the verb complete. What was Mr. Moran allegedly completing? He was completing the fraudulent scripts that my client allegedly pre-signed. Does it use the definitive article "the" in the sentence?
Gracious. I think you're taking this to a new level. My question was, couldn't he have not participated sufficiently for the jury to find beyond a reasonable doubt that he did, but yet knew enough that it was false when he signed that affidavit? It's just a simple question. Isn't that within the realm of possibility?
No, Your Honor, it's not.
Okay, thank you.
The government is...
I said thank you.
And just to follow up on the point briefly, the government is stuck with the false statement that it alleged in the indictment. This court has repeatedly held that. It held that in Hoover. The example there, which is very interesting and there's a subtle distinction, in that case, the defendant was charged with false statements based on double flooring. It was a car dealership, and the concept is that if you have a car and it's collateral for a loan, you can only use that car for one loan as collateral. The false statement that the government charged in that case was whether or not the defendant knew that more than one person complained to him about the concept of double flooring. At trial, the government charged the idea that the defendant knew that more than one person had complained. Subtle distinction, but this court held that that was a constructive amendment, and the court held that that was per se reversible error.
Counsel, is it not possible that your client could still be convicted on any one of the 3 omissions in the affidavit, the alleged omissions?
So the government makes that argument. I don't think this court has to decide that, because even if you focus on the 3rd alleged omission, it's impossible to read it out of context as assuming a fraudulent scheme in which my client's not a part. I'll also point out the practical concern here. I don't understand how the government would send back this indictment in a retrial on count 8 on a non-participation theory. A jury would look at this indictment and it would make absolutely no sense compared to the theory that the government alleged in the indictment. And again, that's a per se violation of the Fifth Amendment grand jury clause. So we know that the government can't try this case successfully under the Fifth Amendment. The jury necessarily found that my client was not a participant in the scheme and acquitting on counts 1 through 7. And count 8, the government would violate the grand jury clause in order to secure a conviction on a non-participation theory.
What must the government prove on count 8 other than the knowledge that the defendant had that was contrary to what was in the affidavit?
So to prove the knowledge in this case, Your Honor, they'd have to prove that he was a participant in the scheme as alleged in the indictment.
But knowledge and participation are two different things, though, aren't they?
Yes, Your Honor, but
It sounds like a misprision type theory at this point. And granted, count 8 is kind of stuck onto the side of this indictment, but I'm trying to understand your argument that it is precluded by a not guilty on the first 7 counts. And it seems like the jury was very discerning in acquitting or finding not guilty, I should say, on the first 7.
Yes, Your Honor, but one thing to keep in mind, on count 8, we don't know why the jury hung, and of course the Supreme Court held in Yeager that we can't figure that out. They could have hung simply because of exhaustion. They could have hung because one juror was confused and thought the government could proceed on a theory that wasn't alleged in the indictment, and the other 11 held fast in saying that that's not the case. The problem here is that the scheme, what the government would have to prove in a retrial on count 8 was that there was a false statement related to my client's participation. If that participation, that scheme as alleged in the indictment, doesn't exist because a jury found beyond a reasonable doubt that rejected guilt on that scheme, then it's impossible for my client to have knowingly failed to disclose the existence of that same scheme. What the government would be proceeding on is this idea that Judge Barksdale alluded to, where my client harbored suspicions after the fact about a completely independent scheme involving Mr. Moran, put those pieces together, and then somehow failed to disclose that. I think that's a...
Do I understand your argument correctly at trial was that there may have been a scheme that was testified to by the cooperating defendant and so on, but your client wasn't a part of it, not that there was no scheme whatsoever. Is that correct?
That's correct, Your Honor. Very interesting case here of sort of he said in this case. There was no doubt that there was a fraudulent prescription scheme. There was no doubt that there were faxes that Ms. Clark, the other defendant, sent to healthcare providers. My client didn't dispute any of this, didn't dispute that the government was built of millions and millions of dollars. The issue here, the sole issue that my client focused on was he a participant in this scheme?
And more specifically, that he did not have the intent to be a member of the conspiracy.
Yes, by not knowing and participating in the scheme, he certainly did not have the requisite intent to have participated in the scheme. And you see this throughout, just some record excerpts so that you understand that the opening statement by defense counsel focused on the lack of participation. This is a he said, she said, as counsel referred to it. The government said this case is simple. It's about the alleged scheme. Cross-examination on every witness, virtually every witness, focused on whether or not they knew that my client pre-signed these scripts and participated in the scheme. When the government's expert testified to the medical necessity or appropriateness of this, defense counsel didn't object at all. He objected as soon as the expert started testifying to the fact that my client signed the scripts in question, and he pointed out that the expert would have no way of knowing. The expert then conceded that if my client didn't pre-sign these scripts, he wouldn't be legally responsible for them. And the defense case carried on throughout. When my client testified, he readily admitted on cross-examination to the government that the scheme, as alleged, was inappropriate. This was not a situation where my client stood up and said, I participated in this scheme, but it was fine. It was medically appropriate. That defense did not come out at all. So the jury here, I think the verdicts are sort of unquestioned. And I understand that under Ash and Yeager, it's a discerning standard. The jury had to necessarily decide. But we know by testing the arguments that the government has given here that the jury necessarily decided that my client was not a participant. If you focus on the government's lead argument, it's quite an awkward argument by the government. The government argues that the jury could have acquitted because, based on a few lines of testimony from Mr. Moran, that he didn't understand that what they were doing broke the law. The government doesn't normally get up in cases involving a knowing level intent and saying that a rational jury could acquit on the basis that you had to have specific knowledge that what you were doing violated the law. And in any event, even if that was the legal standard that was applicable here, my client readily refuted it. On cross-examination, admitted that the scheme was inappropriate and wrong. His medical expert admitted that the scheme was inappropriate and wrong. And for all those reasons, if there are no further questions.
I have a question I want to ask you. Cover for us defendant's testimony at trial, as I understand it from the briefs, where he said, well, when I signed the affidavits, I just wasn't being careful and didn't give it enough attention, or what, I don't remember the exact testimony. Go over that testimony and tell us why that isn't a hook that the government could hang its hat on.
Sure. So what you're focusing on there, Your Honor, is my client testified that he didn't read the affidavits carefully. The affidavits were asking about specific prescriptions that my client allegedly authorized or did not authorize. He focused on a list of names of patients. And so he directed his subordinate, a nurse, Ms. Stokes, to circle only those patients that were his patients. He didn't distinguish between scripts and patients. So that's what happened, and that's what my client admitted was a mistake on his part, that he should have read the affidavit more carefully. The problem here for the government in a retrial is they didn't indict on that theory. They didn't indict on the theory that the affidavit was wrong for that particular reason. They indicted on the theory that my client omitted the 3 steps in the chain of the fraudulent prescription scheme.
Counsel, while we're talking about theories at trial, the defense moved under Rule 29 at the close of all evidence for an acquittal on the basis that the government failed to prove the requisite intent as to counts 1 through 7. So the very distinction that you call awkward from the government's perspective was the defense theory at the close of all evidence under Rule 29.
Yes, but not the theory that was advanced in front of the jury, Your Honor. And
I understand that, but we're talking about a legal question now as to how to unscramble all of this under Ash, and the very theory that you call awkward is the theory that you advanced as a Rule 29 argument at the trial court.
And I will readily concede that that was a mistaken theory to assert on the Rule 29, and the judge appropriately rejected it.
Thank you.
I'm definitely not here to defend that on Rule 29 grounds. I think what's important, though, is that it wasn't renewed in front of the jury. It would be a completely different issue in front of this court if it was renewed in front of the jury, but it was not. And I would submit that even if it was renewed in front of the jury, it still would have failed, because legally the court didn't instruct on it, and my client admitted that the scheme was inappropriate.
Do we normally renew Rule 29 motions in front of a jury? I mean,
No.
It's not a jury question.
No, it's not a jury question. What I mean by that is the defense case rests, the Rule 29 came up, and then the jury's entered back into the room. We have closing arguments, and they get up there and say, doesn't matter if my client participated or not, he didn't have the requisite intent. That would be a different case from this one. Thank you, Your Honor. Are there any further questions?
Thank you.
I'll reserve the balance of time.
If you've reserved 3 minutes for rebuttal, we'll hear from the government now. Mr. Valentini.
Good morning. May it please the court. Francesco Valentini for the United States. Even if the jury found that Dr. Auzenne did not participate in the scheme, the government would be entitled to retry count 8 for all the reasons that Your Honors alluded to just a second ago. But before we get to that point, I would like to spend some time discussing the core of the Ash claim that is at issue in this case. Like any defendant pressing a claim under Ash versus Swenson, Dr. Auzenne has a steep hill to climb. He must show two things. He must show that his acquittal necessarily not just likely, not even very likely, but necessarily resolved an ultimate issue of fact. And second, he must show that that issue of fact was essential to the count that he wishes to stop. The Ash standard is demanding, as the Supreme Court has repeatedly emphasized in Ash itself, in Yeager, and most recently in Currier, and as this court recently emphasized in its en banc opinion in Langley versus Prince. The reason for the high standard is both clear and well-traveled. A judgment of acquittal in a criminal case, unlike a civil judgment, is not subject to substantive review on appeal. And in addition to that, collateral estoppel simply does not sit easily with the text or the history of the double jeopardy clause. In this particular case, at trial, Dr. Auzenne argued primarily, and we recognize that, he argued that he had nothing to do with this scheme to fill fraudulent prescriptions. But that was not his only defense, and it's certainly not the only defense that a rational jury could have acquitted on counts 1 through 7 on. I won't belabor all the points and all the various defenses that Dr. Auzenne floated at trial through testimony and otherwise, but it will focus on one which would cast out on that would not cast doubt on his participation and furtherance of the scheme, but would explain the acquittals on counts 1 through 7. And the jury in particular could have found that it did all the acts in furtherance of the conspiracy that are alleged in the indictment, and yet acquitted on the ground that there was insufficient evidence, not evidence beyond a reasonable doubt, that he intended to defraud, the specific intent to defraud. At trial, the first thing, as I believe Your Honor mentioned a few minutes ago, one of the first things that Dr. Auzenne testified to was that he said, some would say things got sloppy around the office for about 2 or 3 months, and honestly, I just trusted somebody too much. In other words, that's an intent defense. What he said, essentially, is my actions further the conspiracy, or may have furthered the conspiracy. I just didn't know about it. I was negligent. That is a quintessential lack of intent to defraud defense.
Counsel, I'm trying to imagine what a trial on count 8 would look like if we agreed with your position. Would you have to introduce all of the evidence of the conspiracy or scheme, I think was the word we used when Mr. Smith was at the podium? Would you have to prove up all of that, and then that the defendant was aware of what was going on? Isn't that the predicate to him signing the affidavit?
So to be clear, the premise, just so I understand your question, on the premise that we prevail on the Ash claim, then yes, all the evidence would be admissible. It would be admissible as, at a minimum, proof of motive of why Dr. Auzenne lied in those affidavits.
But to lie, he has to know the truth of the matter in order to give an incorrect statement in an affidavit. Isn't that correct?
Yes, absolutely.
And you're alleged that he gave 3 statements in the affidavit, and I believe your argument is that any one of them would constitute grounds for a guilty verdict.
Yes, absolutely. If we prevail on the Ash claim, then the jury could have acquitted simply because Dr. Auzenne participated in the scheme. He knew what he was doing. He just didn't have a downstream intent to defraud. He was not involved in the billing. And this is something that does set this case, this healthcare fraud case, a little bit apart from other healthcare fraud cases in which the provider is directly involved in the billing, or it's the provider's office that does the billing. In this case, Dr. Auzenne was a little bit removed, so perhaps the jury could have, a rational jury could have concluded that he was involved in the production of the false prescriptions. He just did not have an intent to defraud. And in fact, he testified at trial that he didn't know about anything about the billing, that he just wasn't involved. He, I think at some point suggested that maybe some of the patients may not have been insured, or they didn't know whether they were insured, and that's at page 3176 of the record. And so on that theory, then, on retrial, we would be allowed to prove everything, and well, all the evidence would be admissible. We would be allowed to prove his participation on the scheme, and I think the only fact that the first trial would have decided would be the specific intent to defraud. That would not be an element in this case. It would still come in as a proof of intent, proof of motive for the false statement in the affidavits. But that would be the extent of the limitation. Under Dowling versus the United States, there would be no limitation whatsoever on the admissibility of the evidence. To be clear, even if we did not prevail on the Ash claim. I would also say,
I recall, just to narrow things down, I recall in your brief perhaps saying the jury could have found that the requisite interstate commerce connection was missing. I don't believe I'm making this up. Are you sort of dropping all of that now?
I think that was like one of the things that was mentioned below. I don't think that we featured it prominently in our brief. I think the main explanation we think of what a rational jury could have done, and in this case is find a perhaps insufficient proof of intent to defraud. And in fact, that's not just merely a rational explanation, it's actually the more plausible one. Because, as I mentioned, while the proof of intent to defraud may have been arguably, it was strong in our view, but arguably a little bit more indirect, the proof that Dr. Auzenne was in fact, that his acts in fact further the conspiracy was overwhelming. I mean, I believe I heard my friend on the other side characterize this case as a he said, she said kind of case, but this is absolutely not what it is. In this case, Dr. Auzenne himself admitted to the compliance officer for the hospital service that he had authorized prescriptions for these compound medicines. He did it again when he spoke to the compliance officer for Blue Cross Blue Shields in connection with the preparation of the affidavits. And the affidavits themselves are proof of his admissions. These are not just the words of Marco Moran. These are the words of Dr. Auzenne. What proof was, summarize the proof at trial regarding the claimed $127,000 that he received as, quote, consulting fees, close quote. The government's, I think some of the government's proof was, well really, he told Moran to handle it that way because they needed to pause and see how things shook out before he got the rest of what he was owed. But what proof was presented as to the 127 and how that could have been a legitimate payment for consulting fees? So the evidence that we relied on, in addition to the testimony of Marco Moran, was circumstantial evidence. On the other side, if Your Honor is asking about what proof was offered by the other side, I mean, it was essentially just the testimony of Dr. Auzenne. He said, this were consulting, he had the nerve at trial to say, this was actually a low amount for the amount of consulting that I did in this context. So I think the proof that they would point to is the proof of the defendant himself.
This scheme lasted a little over a year, around a year?
Yeah, I mean, I think that the scheme protracted for some time. The prescriptions in this case, though, are limited to a shorter period of time, the spring of 2014. Unless Your Honors have any further questions?
So do I understand correctly that Ms. Clark was originally charged in the indictment but entered a plea after the indictment? Or did she go, I'm looking at the verdict form. The verdict form is only as to this defendant, but it does have both of them listed in the title.
Ms. Clark was a defendant in this case, and she was tried and she was acquitted on this count. And her acquittal underscores if anything, underscores the fact that Dr. Auzenne, that the jury more than rationally would have found that Dr. Auzenne was involved. Because there's no question, there was no question on the record.
Did you have separate verdict forms, or is this just a redacted? Because I'm looking at a verdict form, it's in the record at document 147, and it only has questions, interrogatories to the jury for Dr. Auzenne. And you said she was acquitted on count 8? Ms. Clark was acquitted.
No, she was not charged with count 8. She was charged with some of the counts. I'm sorry, she was not charged with count 8. Of the counts in which she was charged, she was acquitted. And her acquittal, because there was no question on the record.
Understand. Okay. Is there a separate verdict form for the charges against her? I'm just curious as to why. It just seems odd that only he is on this verdict form. So I guess there must have been another verdict form that was returned with not guilties for her.
That's my assumption, and I believe it is possible that because she was a different defendant, it may be that the way the record and appeal is compiled, documents that were specific to her are not included in the excerpts of record, but if Your Honor would like us to follow up, we could follow up on the issue.
Okay, that's right. We can double check it in the record. I was just curious as I was flipping through as you were answering Judge Barksdale's questions, and it struck me as a bit odd. So, okay. Anything further, counsel?
No, Your Honor, unless you have any further questions, we'd ask the court to affirm the denial of the motion to dismiss.
All right. Thank you, Mr. Valentini. Mr. Smith, you had reserved 3 minutes for rebuttal.
Thank you, Your Honor. I'll be very brief. I'll just focus on one of the arguments that the Department of Justice made, which focuses on a lack of specific intent to defraud. I don't think a jury could find on this record, I know a jury could not find on this record, that my client participated in the scheme as alleged, but somehow lacked the specific intent to defraud. The scheme as alleged in the indictment and tried by the government was a pre-baked scheme to defraud. My client pre-signed scripts. He directed his assistant to fill in patient information and fax those scripts to Mr. Moran, so he knew that Mr. Moran was receiving those scripts and understood that Mr. Moran was submitting them. The government's testimony, government's argument at 3176 that my client was unaware on billing, he said he was unaware of the specifics of billing, but he said, I'm sure that claims were billed for payment to the government. There was no dispute that the government was billed in this case. The question was whether or not my client participated in the scheme. And the argument about my client being sloppy, my client said he was sloppy in completing the affidavit that I talked to Judge Barksdale about. That's at page 3236 of the record. What my client testified to about making mistakes was entrusting Mr. Moran at all into his life. That is what his testimony was. It was not that he participated in this scheme, but somehow didn't believe what he was doing was wrong. He conceded the scheme was inappropriate. It would have been outside the medical standard of care. And I didn't hear any other argument to explain the jury's overwhelming verdicts of acquittal on counts 1 through 7. That scheme is then baked into count 8. That's how the government chose to indict this case. It's stuck with that indictment. As this court held in Deschette, an indictment is not putty in the government's hands. It is stuck with how it charged the case. It cannot re-indict this case because it's bound by the statute of limitations. And for those reasons, the two pathways that the government has selected here are barred by the Fifth Amendment. The first pathway, the participation theory, is barred by the Double Jeopardy Clause, and the second pathway is barred by the Grand Jury Clause. And for all those reasons, we'd ask that you reverse the judgment of the district court and remand with instructions to dismiss the remaining count with prejudice.
All right. Thank you, Mr. Smith. We have your arguments, and we will consider the matter submitted.
Thank you, Your Honor.
Thank you. All right, the next case on the docket is number 21-1010.